Namaste, this is Advocate Surya Kundeti. Our class is on Civil Procedure Code 1908 and this class topic is arrest and detention. As usual, before I lecture on the topic, I would like to say that these classes are dedicated to a charitable trust engaged in nutritional development of school-going children and their education as well. So, I hope you will definitely like my class, and as an gratitude, may you please make a small donation of 59 rupees towards charitable trust through the UPI number 9949398998. At the end of this class, there will be a display of a QR code where you can scan it using your UPI app and make the small donation. And in addition to it, I would also like to request you, please do subscribe to my YouTube channel. The more the number of subscribers I keep on getting every day, it will be a direct encouragement for me to make more video classes on the law subject. So that the law is going to be very much reachable to the common man as well through classes. Thank you very much. And now let's get back to our topic, arrest and detention in the Code of Civil Procedure 1908. So, arrest and detention, it is all an execution petition. So this topic is very important because arrest and detention happens after the orders have been delivered by the jurisdictional courts. And what is the procedure for arrest and detention in different scenarios? In general, one of the modes of executing a decree is arrest and detention of judgment debtor in a civil prison. So what is the nature and scope? The code enumerates various modes of execution. One of such modes is arrest and detention of the judgment debtor in a civil prison. So what is the object of this arrest and detention? An executing court may order arrest and detention of the judgment debtor since the object is to make payment. A person arrested or detained in the course of execution of a money decree would not be treated as discharged from his debt. It means that even though a person who is supposed to pay money to another person, and according to the court orders, if the person who is supposed to pay the money is imprisoned, it doesn't mean that he is relieved from paying that money. Even after arrest also, he is supposed to pay the money to the person to whom he owes, and then he will be released from the prison. So this point is very important and is applicable in Negotiable Instruments Act. When arrest and detention may be ordered, when it can be ordered, when the decree is for payment of money, it can be exercised by arrest and detention of the judgment debtor. Likewise, in case of a decree for a specific performance of a contract or for injunction, a judgment debtor can be arrested and detained. So who cannot be arrested according to sections 56, 58, 135, 135A? The following classes of persons cannot be arrested or detained in civil prison. A woman cannot be arrested because to respect the dignity of women. Judicial officers, while going to presiding in or returning from their courts or going to the courts as well. The parties, their pleaders, muktars, revenue agents and recognized agents and their witness acting in obedience to a summons while going to or attending or returning from the courts, all these people cannot be arrested. So members of the legislative bodies cannot be arrested or detained in this execution petitions. Any person or class of persons who arrest according to the state government might be attended with a danger or inconvenience to the public as well. A judgment debtor where the decretal amount does not exceed rupees 2000. In all the cases mentioned above, in all the scenarios mentioned above, a judgment debtor may not be arrested. And the procedure for arrestment, the judgment debtor may be arrested at any time and on any day in execution of a decree. After his arrest, he must be brought before the court as soon as practicable. For the purpose of making arrest, no dwelling house may be entered after sunset or before sunrise as well. And notice according to Order 21, Rule 37 and 40, where the decree is payment of money and the application is made for arrest and detention of the judgment debtor, the court shall, instead of issuing a warrant for arrest, issue a notice calling upon the judgment debtor to appeal and show cause why he should not be committed to civil prison in execution of a decree. So these are all the procedures to be followed in the execution of arrest and detentions in negotiable instruments. An opportunity to judgment debtor of satisfying decree. So proviso to sub-rule 3 of the Rule 40 affords judgment debtor an opportunity of satisfying the decree. So power and duty of the court in this context. The provision relating to arrest and detention of judgment debtor protects and safeguards the interest of the decree holder. If the judgment debtor has means to pay and still he refuses or negates to honor his obligations, he can be sent to civil prison. Recording all reasons. The court is required to record reasons for its satisfaction for detention of judgment debtor. Recording of reasons is mandatory. Period of detention, section 58. The period of detention of the judgment debtor in civil prison shall be up to 3 months where the decretal amount exceeds rupees 5,000 rupees. So up to 6 weeks where the decretal amount exceeds rupees 2,000 and less than rupees 5,000. No detention when decretal amount is less than rupees 2,000 rupees. So release of judgment debtor, sections 58 to 59. A judgment debtor may be released in the following cases: on the amount mentioned in the warrant being paid, on the decree against him being otherwise fully satisfied, or on the request of the decree holder, or on the omission by the decree holder to pay subsistence allowance on the ground of illness also. So these are the grounds where amount can be nullified or the decree can be held. So re-arrest of judgment debtor, is it possible? Normally, a judgment debtor once released cannot be re-arrested in execution of the same decree. But if the judgment debtor is released because of a mistake of the jail authorities, he can be re-arrested. Attachment of property in general. So, a decree may also be executed on the application of the decree holder by attachment and sale of by sale without attachment of property. Nature and scope. The code enumerates properties which are liable to be attached and sold in execution of a decree. Object. The primary object of attachment of property is to give notice to the judgment debtor not to alienate the property to anyone, as also the general public not to purchase or in any other manner deal with the property of the judgment debtor attached in executing proceedings. So property which can be attached according to section 60. Section 60, subsection 1 declares which properties are liable to attachment and sale in execution of decree and which properties are exempt therefrom. All saleable property belongs to the judgment debtor or over which or the portion of which he has a disposition power which he may exercise for his own benefit may be attached and sold in execution of particular specific of property under section 60 is therefore not of any consequence if it is saleable otherwise. So property which cannot be attached, section 60 and 61. The proviso to subsection 1 of section 60 declares that the properties specified therein are exempt from attachment and sale in the execution of a decree. So next one is modes of attachment, section 62, order 21, rules 43 to 54. So rule 43 to 54 of order 21 lay down the procedure for attachment of different types of movable and immovable properties. What is a perspect according to section 46? Means a command, a warrant, or writ and an order. And the nature and scope of this order is a precept in an order or direction given by the court which pass a decree to a court which would be competent to execute a decree to attach any property belonging to the judgment debtor. What is the object? The principal object of attachment by precept is to enable the decree holder to obtain an interim attachment of the property of the judgment debtor situate within the jurisdiction of another court where it is apprehended the decree holder may otherwise be deprived of the fruits of the decree. Limitations. Any order or present is merely a step taken to facilitate execution and not an order transferring a decree for execution. So garnish order, of all the orders, this is a wonderful order. Rules 46A and 46 sub rule 1. In general, garnish proceedings is a proceeding by which the decree holder seeks to reach money or property of the judgment by which the decree holder seeks to reach money or property of the judgment debtor in the hands of a third party. What it means is, for example, if somebody stands as a surety and the person who is standing as a surety has pledged his property as well as his salary also. So according to the garnish order, his salary will be attached first rather than the property because salary is hot in cash, whereas property has to be converted to cash. It takes time. So garnish order is attaching a salary of somebody else who has stood as a guarantor for a debtor. So meaning of this, garnish means a judgment debtor's debtor. So for example, suppose A owes rupees 10,000 to B and B owes 10,000 to C. By garnish order, the court may require A not to pay money owed by him to B, but instead to pay C, since B owes the said amount to C who has obtained the order. So, what is the object of this? The primary object of a garnish order is to make the debt due by the debtor for the judgment debtor available to the decree holder in execution without driving him to a suit. Doctrine is well explained in rules 4A and 46(1) have been nearly introduced in the code by the Amendment Act of 1976. They lay down the procedure in garnish cases. So, what is the notice to be given? Rule 46A requires a notice to be issued to the garnishee before a garnish order is passed against him. Effect of payment. The payment made by the garnishee into the court pursuant to such notice shall be treated as a valid discharge to him as against the judgment debtor. Failure to pay. Against failure to pay, the court may ask the garnishee to comply with such notice as if such order were a decree against him. And the costs of garnish proceedings are at the discretion of the court, whether to levy or not to levy. And appeal, yes, orders passed in garnish proceedings are appealable as decrees. And wrongful garnishment may give rise to an action for damages. So, determination of attachment, which is rules 55 to 58. An attachment under the code will be determined in the very limited circumstances. What are those? Where the decretal amount is paid or the decree is otherwise satisfied, where the decree is reversed or is set aside, where the court upholds objection against the attachment and makes an order releasing the property, where after the attachment, the application for execution is dismissed, where the attaching creditor withdraws the attachment. So, in such circumstances, we can ask the courts for determination of attachment, which is rules 55 to 58. So, accordingly, we have the next important topic as private alienation of property after attachment. Private alienation means which is defined in section 64, and the nature and scope of this section is that section 64 subsection 1 enacts that a private alienation of property after the attachment is void against claims enforceable under the attachment. Object. The primary object of this provision is to prevent fraud on decree holders and to keep intact the rights of attaching creditors and of those creditors who have obtained decrees and are entitled to satisfaction out of the assets of the judgment debtor. Interpretation of this one is that the provision interferes with the rights of the owners in alienating his property, and hence it should be constructed strictly. Again, as the provision is for the benefit of attaching creditor, he can waive the benefit. Private transfer, what does it mean? A private transfer means a voluntary transfer such as sale, mortgage, lease, gift, etc., and not a transfer by operation of a law such as sale under a decree passed by a competent court. So, in the same manner, questions are to be determined by executing court. So, in general, section 47 is one of the most important provisions in the code relating to execution. According to section 47, questions to be determined by the court executing decrees, all questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. So, what is the object of this? The underlying object of this provision is to provide a cheap and expeditious remedy for determination of certain question in execution proceedings without a recourse to a separate suit to prevent needless and unnecessary litigation. Section 47 thus therefore must be considered liberally. And what is the nature and scope? The scope of section 47 is very wide. Exclusive jurisdiction has been conferred on executing court in respect of all matters relating to execution. What are the conditions? For applying this section, the following conditions to be satisfied. The question must be one arising between the parties to the suit in which the decree is passed or their representatives, and it must relate to the execution, discharge or satisfaction of the decree. Powers of executing court. An executing court has a plenary power to determine all questions relating to execution of a decree. Duties of executing court. An executing court cannot go behind the decree. It has to execute the decree as it is. Objections to validity of decree. Objection as to its validity can be raised in execution proceedings if such objection appears on the face of the record. What are the general principles? Bar of suit. Section 47 of the code bars a suit in respect of any objection in relating to execution proceedings. How? Through an appeal. Before the Amendment Act of 1976, the determination of a question under Section 47 was deemed to be decree within the meaning of Section 2, subsection 2 of the code, and was therefore subject to first appeal under Section 96 and also as a second appeal under Section 100. So, what are the revisions allowed in such objections? Since after the Amendment Act of 1976, an order under Section 47 does not amount to decree if it is not appealable under Section 96 and Section 100. So, pending matters. Section 97 of the Amendment Act of 1976 declares that the amendment made in Section 2, subsection 2 will not affect pending appeals and they will be dealt with as if the amendment had not come into force. So, in the same manner, we have some more like adjudication of claims. What is it? What is the nature and scope of this one? Position prior to Amendment Act 1976. The executing court used to deal with investigation of claims and objections summarily. So, position after Amendment Act 1976, all questions are to be settled finally in execution proceedings itself and not by a separate suit. So, what is this scheme? Where any property is attached in execution of a decree, it is always open to the parties, their representatives or third parties to raise objection against such attachment. Such suits fall under Section 47. So, what is the objections? According to rules 58 to 63 of Order 21, deal with adjudication of claims to and objections to attachment of property. So, Section 47 and Order 21, Rules 58, what are the distinctions between these orders? Both Section 47 and Order 21, Rule 58 of the Code are similar in certain aspects. There is essential distinction between the two. Whereas, Section 47 applies to parties to the suit, Order 21, Rule 58 applies to third parties, particularly in garnish orders. Who may apply? Any person who at the time of attachment of property has some right, title or interest in or possessing of the property attached may lodge a claim or raise an objection against the attachments. Where application lies, a claim application may be filed in the court which has attached the property, where a special suit confers exclusive jurisdiction on a particular court, a petition can only be filed in that court. So, stay of sale, what is this? The court may, if the property is movable, postpone the sale of, or if the property is immovable, make an order that the property shall not be sold. So, now we have suit. Subrule 5 of Rule 58 declares that where a claim preferred or objection raised is not entertained by the executing court on the ground that the property was sold before the claim was preferred or objection was raised or claim or objection was designedly or unnecessarily delayed, it is open to the aggrieved party to file a suit to establish his right. What is the appeal in this one? An order passed by the executing court in adjudication of claims and objections shall have the same force and is subject to same conditions as to appeal or otherwise as if it were a decree. So, revision: an order of adjudication passed under Rule 58 of Order 21 is treated as decree and appealable. No revision therefore lies against such order. Pending matters: Section 97 of the Amendment Act 1976 declares that the provisions of Rules 58 to 59 would not apply to pending proceedings. So, this is all the important points that are to be remembered in arrest and detention related to execution proceedings. So, as I have been telling earlier in all the classes, these classes are compiled and dedicated to a charitable trust by name ABC Trust, and as you are happy with my class, I believe, I would like to make a request to please donate 59 rupees to a charitable trust, ABC Trust, through a UPI number 994939 8998, and at the end of this class, A QR code is going to be displayed where you can use that QR code to scan and make the donation of 9 rupees. And all your donation is going to be utilized for enrichment of nutritional benefits in the school going children and for their education as well. And one more important point is, I would like to request you to please subscribe to my YouTube channel, because your subscriptions are directly proportional to my encouragement to do more and more law classes, so that the entire nation is going to get benefited with the free law education by all means. And thank you very much. Namaste.